So what is the difference between negligence and negligence per se? It's a legal distinction. A negligence claim requires the plaintiff, and this is the vast majority of negligence claims, by the way. The plaintiff has the burden of proof. We have to prove that the defendant acted negligently, that the defendant's negligent act caused your injuries, and that your injuries resulted in damages. So that's a typical rough outline of a negligence claim. Negligence per se means that the defendant's conduct is so egregious that the burden of proof actually shifts. And if all you have to do is prove that they actually did what you said they did, and then they have to now, instead of you having to prove your case and all these elements, the burden of proof legally shifts to them. Two most common examples of negligence per se. Let's see, dog bites. That's probably the number one example. There are Florida statutes that address certain types of negligent actions, and a dog bite is a negligence per se action. So if your dog bites me, all I need to prove is that your dog bit me, and then the burden shifts to you, and you're almost all the time out of luck. I mean, usually if I can prove that your dog bit me, then statutorily I've met my burden of proof, and it's just a matter of how much are my damages worth. The reason is certain actions. A dog is such an inherently dangerous animal. An owner of a dog is charged with an affirmative legal duty to protect other people from their dogs. So, in that situation, there's not many defenses if your dog bites someone. I'm trying to think of other examples of negligence per se. I remember another one from law school that more applies to defamation and slander laws. If you say something bad about someone and you hurt their reputation, that person can sue you for defamation, but they have the burden of proof. But there are certain statements that are so bad that if you say them about someone, then that burden shifts back to the person who said them. If you accuse someone of having a sexually transmitted disease, that statement in and of itself is so inherently damaging that if they prove you made that statement, then the burden shifts back to you, and you have to prove that it's true. If you can't prove it's true, you're out of luck, and it's defamation per se. Really, if it is a legal distinction. I know I haven't given you more or the best examples, or maybe not even done the best job explaining it to you. All I will tell you is the difference between negligence and negligence per se is a legal distinction, and to attorneys, it's a significant legal distinction because it shifts the burden of proof. If you have questions about your situation, or you think something may fall under negligence per se, feel free to give us a call. I'll be happy to talk with you more about it at 1-800-TRIAL-PRO or chat with us at trialpro.com.